In this lecture, I mentioned that right to property is no more a fundamental right. In late 1960s, it became a bone of contention and the government entered into bitter debates with the Supreme Court regarding the deletion of fundamental rights from Part 3 of the Constitution. Finally, the theory of committed judiciary came out. It was uttered by Sri S. Kumarmangalam and it was supported by the then Law Minister Mr. Gokhale. Ultimately, Mrs. Gandhi's government had a triumph over the judicial conservatism and the said right was shifted from Part 3 of the Indian Constitution. Let us now focus on the present position of the right to property. The Constitution originally provided for the right to property under Article 19 and Article 31. When independent India first adopted its constitution, the right to property was enumerated in Article 19, Clause 1, Subclause F and in Article 31. It was then a fundamental right. Article 19(1) Clause F guaranteed to all the citizens the right to acquire, hold and dispose of property. Article 19(1) Clause F, Subclause F had to be read along with Article 31 of the Constitution. Article 31 provided that no person shall be deprived of his property save by authority of law. It also provided that compensation would be paid to a person whose property has been taken for public purposes. The provisions for relating to right to property was changed a number of times. Most significantly, in 1978, the ruling Janata Party passed the 44th Amendment to the Constitution of India. As part of these amendments, both Article 19(1) Subclause F and Article 31 were deleted from Part 3 of the Constitution and they were converted into a mere legal rights. Article 31 Clause 1, which provided that no person shall be deprived of his property save by the authority of law, was shifted to Chapter 4 of Part 12 in the form of Article 300A. Thus, if a legislature makes a law depriving a person of his property, the state may not feel the obligation to pay anything as compensation, as it was the case when Article 19, Clause 1, Subclause F and Article 31 were parts of fundamental rights. The aggrieved persons shall have no right to move to the court for reinforcement of his fundamental right under Article 32. If the government appears to have acted wrongfully or unfairly, the action can be challenged in an ordinary court of law by a citizen, that is not directly under Article 32. Article 300A now reads as follows: no person shall be deprived of his property save by authority of law. Law. What does a law mean? It means legislation or statute enacted by the Parliament of India. That is, it can never include any executive discretion or executive decision. The liberalization of the economy and the government's initiative to set up special economic zones has led to many protests by farmers and has led to call for reinstatement of fundamental right to private property. The Supreme Court had sent a notice to the government questioning why the right should not be brought back. But in 2010, the court itself rejected this bill. Let's turn our eyes to right to life and personal liberty. The Constitution guarantees right to life and personal liberty, which is the very basis of the right to freedom. Let us now focus on certain specific provisions which enforces these rights. Article 20. Protection in respect of conviction for offences. Article 21. Protection of life and personal liberty. Article 21A. Right to education. Article 22. Protection against arrest and detention in certain cases. Protection in respect of conviction for offences. According to Article 20, no one can be punished which is more than what the law of the land prescribes at that time. It is based on the principle that no criminal law can be made with retrospective effect. Thus, an act to become an offence, the essential condition is that it should have been an offence for violation of law remaining effective at the time of committing the said offence. The other principle which guides Article 20, no person shall be prosecuted or punished for the same offence more than one. It is known as the principle of double jeopardy. That is, no person can be convicted twice for the same offence which have been defined by Anglo-Saxon law. This principle was first established in Magna Carta of Britain. Moreover, no person accused of any offence shall be compelled to be a witness against himself. This article is known as a safeguard against self-incrimination. Protection of life and personal liberty. Article 21 guarantees that no citizen can be denied of his life and liberty except by law. This means that a person's life and personal liberty can only be disputed if that person has committed a crime under the law existing at that time in India. Without access to basic education, no liberty can be enjoyed. We all know this. Therefore, the right to education is having a special significance in a democracy. Article 21A has thus been made a constituent part of right to life and personal liberty. Article 21A ensures right to education. In 2002, through 86th Amendment of the Constitution, Article 21A was inserted in Part 3 of our Constitution. What does it ensure? It ensures a fundamental right for every child to get free and compulsory education. It made the right to primary education part of the right to education of a child, stating that the state would provide free and compulsory education to the children belonging in the age group from 6 to 14 years of age. After 6 years, an amendment was made for this particular insertion. By this amendment, this amendment bill was cleared by the Union government in 2008. Now, as it stands now, the Right of Children to Free and Compulsory Education Act, or Right to Education Act, that is RTE, is an act of the Parliament of India enacted on 4th August 2009, which is based on provisions of Article 21 Clause A, as inserted by 86th Amendment of Indian Constitution. It describes the modalities of the importance of free and compulsory education for children from 6 to 14 years of age falling under Article 21A of the Indian Constitution. Article 21A and RTE Act came in force with its full form on 1st April 2010. The title of the RTE Act incorporates the word free and compulsory. Let us now examine these two words. Free education means that no child other than a child who has been admitted by his or her parents to a school which is not supported by the appropriate government shall be liable to pay any kind of fees or charges or expenses which may prevent him or her from pursuing and completing elementary education. Compulsory education casts an obligation on the appropriate government and the local authorities to provide and ensure admission, attendance and completion of elementary education by all children in this age group, that is 6 to 14. With this, India has moved forward to a right-based framework this framework imposes a legal obligation on the central and the state government for implementation of this basic fundamental right, that is right to education to the children from 6 to 14 age group. India became one of the 135 countries of the world who adopted right to education as its fundamental right. The RTE Act puts the responsibility of ensuring enrollment, attendance and completion of education of a child on the government. In USA and certain other countries, it is parents' responsibility to send the children to the school. The Act makes education a fundamental right of every child between ages 6 to 14 and specifies minimum norms of elementary school. Secondly, it requires all private schools to reserve 25% of seats to these children whose fees will be reimbursed by the state as part of the public-private partnership. The Act also provides that no child shall be held back, expelled, or required to pass a board examination until the completion of elementary education. There is also a provision for special training of school dropouts to bring them up at par with the students of the same age. Thus, RTE Act provides for rational deployment of teachers by ensuring that the specified pupil-teacher ratio is maintained for each school. As it has been enshrined in the Constitution, it ensures all-round development of the child, building on the child's knowledge, potentiality, talent, and making the child free of fear, trauma, anxiety through the system of a child-friendly or learner-centric training in a school. A number of other provisions regarding improvement of school infrastructure, teacher-student ratio, and faculty are mentioned in RTE Act. The right to education of persons with disabilities until 18 years of age is laid down under a separate legislation, the Person with Disabilities Act. Let's concentrate on some prohibitions. It prohibits physical punishment and mental harassment to children. The Act prohibits screening procedures for admission of children. capitation fee, private tuition by teachers, and running of schools without recognition. Article 22. Protection against arrest and detention in certain cases. Article 22, Clause 1 says that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Article 22, Clause 2 says that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate. And no such person shall be detained in custody beyond the said period without the authority of a magistrate. Article 22, Clause 3. It says that nothing in clauses 1 and 2 shall apply to a person who for the time being is an enemy alien, or to any person who is arrested or detained under any law providing for preventive detention. Article 22, Clause 4. No law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months, unless an advisory board consisting of persons in status or qualification of being the judges of High Court has reported before the expiration of these 3 months that there is, in its opinion, sufficient cause for such detention. Article 22, Clause 5 says that when any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order as soon as may be communicate to such person the grounds on which the order has been made, and shall afford the earliest opportunity of making a representation against the order. Thus, Article 22 guarantees 3 basic freedoms. It guarantees that the right of every person who is arrested to be informed of the cause of his arrest. Secondly, his right to consult or to be defended by a lawyer of his choice. And thirdly, an arrested citizen has to be brought before the nearest magistrate within 24 hours. Beyond this 24 hours, without any valid reason, no person can be detained without the authority of the magistrate. A right of a person arrested under ordinary circumstances is laid down in the right to life and personal liberty. As I have already said, that no right can be absolute. Reasonable restrictions can be imposed by the authority of law. So, this particular right is also subject to certain restrictions. The provision of preventive detention and suspension of fundamental rights in times of emergency, or the provision of acts like the Maintenance of Internal Security Act (MISA) and National Security Act (NSA) are the means to disregard fundamental rights, because they sanction extraordinary powers to the state for fighting internal and cross-border terrorism and political violence. But the government and the ruling party, as well as the opposition, must ensure that these provisions must not be used out of any political ill will. Only the vigilant public opinion can prevent the state from using such acts out of political ill will and from becoming the government a dictatorial one. This right to life and personal liberty are subject to several criticisms. Critics have clarified their points of their perspectives from different angles. The right to personal liberty has been said that it is full of ambiguity. The phrases like public interest are ambiguous, and this ambiguity may invite political overtoning. The phrases like security of state, public order, morality are of wide implication and may be defined by different government in a different way, because all the government are formed by specific ruling parties, specific political parties having their own sort of ideologies. Unless it is very specific, precise or well defined, it may be of different implications. The meaning of phrases like reasonable restrictions and the interest of public order have not been explicitly stated in the Constitution, and this ambiguity leads to unnecessary litigation. The government restricts this freedom in the interest of independence, sovereignty and integrity of the nation. But in such cases also, strict vigilance by the opposition is required. During emergency period of 1975, the provision was widely misused. The provision of preventive detention and suspension of fundamental rights in times of emergency, or the provision of the acts mentioned above, are the acts which harm democracy, which are impediments in the way of democratic values and curtails the rights of the people. It makes the government a despotic one. However, once again, we must mention that right to life and personal liberty cannot be suspended even during emergency. Last but not the least, only alert citizens able to form strong public opinion can only save democracy. Provision of legal aid needs to be strengthened to do justice with the detained person, especially belonging to poorer and weaker sections of community. All these fundamental rights are like ornaments mentioned enumerated in the Constitution of India, but they are to be used properly, implemented properly, and all the institutions of government, opposition, and most prominently enlightened citizens are required for reinforcement of these fundamental rights in proper sense of term.